What I would like to do is kind of address some issues that I believe injured workers that may not have an attorney, or that is so overloaded with cases that into the case that they kind of should, especially for injured workers who've been in the system a long time. Because being in the system for this long, then our whole case becomes a whole new issue. I think that was law last week, this week, and so it makes it really, really hard. Doing kind of okay until SB 899 came along. When 899 came along, I lost. I had filed for insurance fraud penalties, 366 of them. I lost 366 penalties because of SB 899. Insurance violations, they were just kicked out. We have a new law now. My date of injury was February 16th, 1994. I'll give you a little bit of a background. That was 19 years ago. I was young, now I'm old. I was working as a labor and delivery nurse at a hospital, and a patient who was in labor and having a baby kicked me in the head. My head struck a concrete wall. She shoved my jaw up my skull. She knocked my teeth out and broke my neck. I immediately filed an insurance form. The next day, I wanted to get my teeth fixed, and that's when it started. The hospital that I worked at, who is also self-insured, turned around and said, well, the ER doctor didn't see anything, so there's nothing wrong with you. Oh, it must have been your husband who kicked your teeth out. I've heard it all. I then pleaded. I did go to a dentist. The dentist said I had this traumatic injury, and we need to fix this. 19 years ago, I paid out of my own pocket to have some of my teeth temporarily put in. I am now still in litigation to get my teeth fixed. It's unbelievable. In 2001, I believe it was in 2001, I actually got an award and order from the Workers' Compensation Appeals Board. It was an uncapitated medical award for all my injured body parts, no cap limit on it, and for benefits. The employer appealed this decision, and I got a new attorney. They got rid of their first attorney, got a new attorney. He appealed it. It went all the way to the California Supreme Court. California Supreme Court said this order stands. I'm entitled to treatment. I'm entitled to benefits. I should get treatment. I had several physicians declare me 100% disabled. They actually wanted me to get temporary total disability at the time and get treatment. I then faced the challenge that I had the attorney start writing letters to my doctors saying she never got an award. Don't treat her. If you treat her, you're not going to get paid. Well, that's really hard when you've got doctors that want to treat you and now they're not getting paid. So most of my care has been done on lien bases, and the liens were never paid. Now, with the last new law, this SB 899, before this one, the liens were all thrown out of court. The lien claimants had to walk away with nothing after spending thousands of dollars trying to treat me. In 2000, I had jaw surgery 4 years after injury. I was diagnosed with having a severe closed head injury. I suffered a lot of depression. I was supposed to see psychiatric help and everything. I was sent to a psychiatrist who said that I had a psychotic episode, that this injury never happened, and that I suffered from fictitious disorder, meaning I was imagining all my injuries. So this is really hard. You get really depressed, you're really down. When I tried on my own fruition to help myself to get better, they came and accused me that there was nothing wrong. And at the last stand, it was so bad that in 2006, I had a spinal surgeon who requested that I have spinal surgery. There were specific laws the insurance company was supposed to follow. They were supposed to send it through second spinal surgery opinion procedure. Knew that. They didn't do that. they wrote to my doctor and said, oh, why don't we give her a pain shot instead of doing spinal surgery? By then, it was so bad that the spinal surgeon on an emergency basis had to do a spinal surgery on me, which now the federal government has paid for. Medicare paid for it. For 5 or 6 years, I have now been fighting in the court system to get the court to force the insurance company to pay the federal Medicare program back. The only thing the court did for me was say, yes, the spinal surgery was industrial related. Yes, they are responsible for the spinal surgery, but no one says pay back the federal Medicare program. So here, the federal Medicare program now has been paying a big bulk of my treatment. In the whole interim process, I complained about them not following the law, and I was writing letters to the federal government complaining, which got me 8 restraining orders for workplace violence. I was handed 8 restraining orders for workplace violence, and...
For writing letters?
Yes, sir. For writing letters to the federal government, which I did, and I took the 8 restraining orders, and I'm not an attorney, and so I answered the 8 restraining orders because I had to answer them. By answering the 8 restraining orders, the defendants took it to the court, all the way up to the 9th Circuit, federal court and everywhere, and had me declared a vexatious litigant in the state of California, meaning that there is no court arena I can ever file a suit again because I'm declared a vexatious litigant, meaning when I go back to the work comp judge because I need treatment, I have to get approval from the judge that it's okay for me to do that because I'm a vexatious litigant. So it's really dampened my rights in the court system. When I questioned why they did, that they were writing letters to the federal government, then I had a civil racketeering trial going. And upon questioning the insurance company and the claims adjuster, well, why did you get a restraining order against her? They testified under oath before a sworn jury that I had in actuality written death threat letters to their employees and their families, and that a psychiatrist had said that I was a dangerous person to society. I have now been trying since 2008 to obtain copies of those death threat letters and the psychiatric report, and no one's to be able to give them to me. I have now filed an investigation for penalty of perjury and fraud on the court. I do not know if this is going to go forward, but it was penalty of perjury. They lied in front of a sworn jury in a civil arena. So we'll see how that goes. So that's a little bit of my background. I'm still waiting for the new law. Went into January 1st, and once I heard about the new law, I actually had a judge tell me that these medical reviewers, he calls them the black hooded doctors, the doctors with a hood on them, since you're not allowed to know anything about them. You're not allowed to know their name, where they are, their background is, or anything. So I kind of looked at the case closely, and I thought, like all the other doctors today have talked, I have been so diligent about documentation, and I've been very blessed to have doctors who have done a phenomenal job documenting my injury, writing everything down to the T. So I thought to myself, okay, this isn't too bad. Let's take it through my request for treatment, let UR deny it, and then can go to IMR, independent medical review. What the insurance company in my case now is doing is they're not sending it to UR. So when my primary treating physicians request for authorization for a medication I need, they do not send it since January 1st. They are not sending it to UR anymore to be either denied or approved. They're coming back and writing to my doc saying, oh, we're denying this because utilization review denied it last year and denied it the year before. So they're basically now circumventing the utilization review process, therefore denying me the right to independent medical review. In the law, there is nothing in there that punishes insurance companies for doing that. So this is kind of untrodden area because I'm having to go back to the judge now and say, hey, wait a minute, they didn't send it to UR. I can't go to IMR. How am I supposed to get treatment? So this is uncharted it's the other thing that they're also doing is they approached me because I need all this very expensive work. So they approached me and said, why don't you pick your own dentist, go to the dentist, get an evaluation, and then we'll pay for the treatment because we don't want to go through UR. So I said, hallelujah, maybe finally now they want to treat me. So I found a dentist, finally, who would even touch me, did an evaluation. I paid for that evaluation, assuming I was going to get the money back, sent the bill to the insurance company, and the insurance company came back and said, oh, he's too expensive, we don't want to pay anymore. So I'm going to trial now again on this money they told me to spend, that I did spend. Now, then they said, oh, go back to him again and find out what needs to be, and we'll pay for it. So I just went back again, and bless his heart, this doctor is smart enough to have told the insurance company, so he's asked for a retainer to get this treated, and then, so not going through UR and telling me to cover this, the issue of just treatment has now been going on for 2 years. The idea of SB 863, that your treatment delays from 1 year to be cut down to 40 days, is ludicrous. Because now into two situations where utilization review, it was sent to UR, utilization review, I need this medication. So I went to the pharmacy. They called the claims adjuster up, and the claim, no, she can't have the medication, let her fight it. So this new law has, SB 899 did it, this new law has done it even worse. The injured worker, the unrepresented injured worker, there are no more penalties. The penalties which are there are worthless. It's more paperwork and more money to try and get a penalty. The old penalty is gone, the 10% increase. I was awarded 2 of those. I have one standing, and they don't even pay those penalties correctly. That's from 2001. And the injured worker really has no more rights because your stuff is going to doctors that you don't even know. And then if the insurance company doesn't want it to go to the IMR, they just stall you. And it's a stalling process. So my whole thing is, what I'd like to see is injured workers have to really educate themselves. And I understand the depression, I understand the hopelessness. I was a single parent with 3 small children. I lost everything. My then 14-year-old was taking care of himself until he graduated from high school. I, at the time, had a 10-year-old who got a job digging ditches to help us out. They're all adults now, but I know how it is to lose everything. I know how it is to live on the street. I spent several months living out of my car in Sacramento to understand how the system worked. I would go in and out of the Capitol building on a daily basis. I know the money shuffling, I know the bribery, I know the corruption. So the biggest thing is injured workers need to educate themselves. They need to stay on top of their cases. They need to be diligent about their paperwork if they're unrepresented. And if they are represented, they need to remind their attorneys there are timelines. If utilization review denies a medication, you have 30 days. 30 days to get an IMR. If you're an unrepresented injured worker and you're not feeling good and you're depressed in bed, 15 days goes by in a heartbeat. And you still don't have your paperwork in order. And if you don't get it in, you're out of luck. So a lot of it is, if I can send anything away from this, is that I really hope that injured workers can gather up the strength and start educating themselves, and if nothing else, ask questions. We have a wonderful organization. There are lots of organizations out there. Ask questions, get on the internet, send people emails, say, hey, what do I need to do? I answer questions all day long for people. They say, what form? I find form for them, I download it, I send it to them. They don't know the timelines. I try to explain it to them. I try to explain if they can't speak English, because like our attorney here explained, I'm not a citizen of the United States. I came here as a legal alien when I was 19 years old, and I had to learn. I knew some English, but I had to get better, and I have gone through that where doctors have questioned my immigration status and are you legally here, because when it comes to the part where you fill out where you were born, I was born in Africa. So they look at me and they go, okay, what's your immigration status? That's been questioned. My family background's been questioned. I have been put through the ringer, and I have been chased around. And the worst part was just recently, I saw my spinal surgeon because I'm probably facing another spinal surgery because this fusion is going bad. And he told me that the defense attorney questioned him, that he was a liar, that he never really did spinal surgery on me because you can't see a scar. Well, I had a really good spinal surgeon who saved my life. And so those kind of things I'm fighting. And I guess in my case, the worst thing is that I tried to settle my case. And because I'm a Social Security recipient, I had to get a Medicare set-aside done, which is something I also wish attorneys remind their clients of if they're security recipients. I had a Medicare set-aside done. The defendants had a Medicare set-aside done. They know the liability. This Medicare set-aside was actually done by the federal government. They know their liability. They know what it's going to cost them, which is something I also wish attorneys remind their clients of if they're security recipients. I had a Medicare set-aside done. The defendants had a Medicare set-aside done. They know the liability. This Medicare set-aside was actually done by the federal government. They know their liability. They know what it's going to cost them. They don't want to sell. They just want me. I don't know what they want me to. So on average, I file twice a year, or once a year at least. On average, I probably have 3 hearings. I now do them by telephone because I moved out of the state of California. But the insurance company, in my case, has probably racked up more money in legal fees and in attorney's fees and wasting the court system that it would have been to just fix me and let me go back to work. And this cost shifting, the federal government, I mean, I am utmost grateful to the federal government for giving me a Social Security check and paying for some of my treatment, but it shouldn't be that way. It shouldn't be that way, and I just hope that if we gather together and are together as a group, we can get the strength to change this, because I can only see bad things coming down the road, especially when people can't get treatment. And so I just hope that my little thing here will somewhat help. This new law is brand spanking new. I'm actually going to trial in June on the whole issue of the utilization review, circumventing it, not letting me to go to IMR, false promises. I don't know how it's going to end out because it's brand new. So we'll have to wait and see.